𝗟𝗂 Law is one of the top immigration law firms in the USA. 100 officers, including law clerks and case managers, work in different departments under the supervision of attorney 𝗟𝗂 and other associate attorneys in the United States. The success rate of 𝗟𝗂 Law is over 99% in fulfilling the dream of people from other parts of the world. Family-based, employment-based, asylum, and green card-related services are available under one umbrella in 𝗟𝗂 Law. In addition, this law firm is one of the best in the United States for obtaining services related to NIW, writ of mandamus, and student visas. The headquarters of 𝗟𝗂 Law is in Washington, D.C. metropolitan area. We have a branch office in Atlanta, Georgia, to reach the services easily of 𝗟𝗂 Law to everyone living in Georgia. Besides, we have a country office in Bangladesh. The contact address and phone number are shown for any immigration-related services. You can also email info@𝗟𝗂law.com. 𝗟𝗂 Law is your safe address for assistance and advice regarding immigration to America.
Hello, everyone. It is my pleasure to welcome you all to the weekly live session held by attorney 𝗟𝗂 and Associates. For today's host, I am Isabella Rosario, and with me I have Mr. 𝗟𝗂, the founder and the principal attorney of attorney 𝗟𝗂 and Associates. For today's discussion, we have the topic marriage-based green card application. A marriage green card allows the spouse of a U.S. citizen or green card holder to live and work anywhere in the United States. A green card holder can then have permanent status until they wish to apply for U.S. citizenship. But we will listen to more in details from Mr. 𝗟𝗂 himself. Welcome, Mr. 𝗟𝗂, and we are all very excited to hear more about this topic from you.
Thank you very much, Isabella, and thank you very much, everybody who is watching this video right now, or you'll watch it later from our YouTube or Facebook page. So yes, marriage-based green card application is one of the main platform by which a lot of people from all over the world, they come to America every year and they get green card status. And also there's also a lot of fraud in this sector. That's why we see a lot of guidelines from USCIS. In many interviews, a lot of people, they lose their green card application because they cannot provide enough evidence of bona fide marriage. That's why I decided to talk about this. And if you need any help in the future, please feel free to reach out to us for help. So when you, apply for marriage-based green card application, just remember two words. The most critical two words are bona fide marriage. You have to establish that the marriage you have with a U.S. citizen or a permanent resident is bona fide. The sole purpose of that marriage is to form a family and live in peace, not for any immigration purposes. Any immigration benefit that you are getting from this marriage is your extra. That's not the purpose of your marriage. So you have to establish that is called bona fide marriage. So whenever you submit any application for marriage-based green card application, all the documents, all the information you provide must be true and accurate, and may not submit any information that is fraudulent and frivolous. So a lot of people, they do that, and I see a lot of people, they get rejected in the application. So please make sure that all the information you submit, all the document you submit is true and accurate. So marriage-based green card application has two steps. In many cases, you can apply both of the steps together. And in some cases, you have to wait for the first one to be approved and then apply for the second step. So the two steps is, the first one is called I-130. So I-130 is name of the firm. You have to fill it up, submit it to USCIS. Technically, your spouse who is a US citizen or permanent resident will fill it up and submit to USCIS with appropriate USCIS filing fee and other supporting documents. Once I-130 is approved, then whether you will submit I-485 or immigration visa process, IVP, in your local US embassy, depending on where you are living. If you are living in America, then you will submit I-485 form with some other forms and supporting documents and filing fee, everything. However, if you are living in a foreign country at that moment, you have to apply for an immigration visa in your local US embassy. Let's say you live in Pakistan and your spouse applied for I-130 and you got approved, and then you submit your IVP in your local US embassy. So whether you're going to apply for I-485 or whether you're going to apply for IBP, it requires a lot of different kind of supporting evidence and different kind of information. So please remember that you have to follow this rule. Also, if you are living in America, sometime you can apply for I-130 and I-485 together. Sometime you cannot submit these two applications together. You have to wait for I-130 to be approved and then apply for I-485. Whether you will be able to apply these two forms together or you have to wait depends on visa bulletin. And recently there's a huge changes in the visa bulletin. In the April 23 visa bulletin, there's a lot of changes. I encourage all of you, those who are trying to apply for marriage-based application, please check visa bulletin whether your category is current or not, and then you apply for marriage-based application. How to read visa bulletin is sometimes a little complex for a lot of my audiences, so I encourage you to learn how to read the visa bulletin, because visa bulletin is very important for pretty much all kind of immigration matters. And we have a YouTube video about how to read visa bulletin, how to understand visa bulletin. If you are interested, please go to our YouTube channel and watch that video. I tried my best to make it very clear, and there are some other videos in YouTube too, and yeah, if you try, it's not that hard to understand. So again, visa bulletin is very important. So let me summarize. In marriage-based application, you have to establish that this is a bona fide marriage. This is not a marriage for the purpose of immigration. If there's any chance the USCIS officer is thinks that this is an application just for the immigration purpose, there's a big chance that your application will be rejected. It must be a bona fide marriage. At first, your spouse, who is a US citizen or permanent resident, must apply for I-130 form. Once it is approved, you will be able to apply for I-485 or IBP, depending on where you are. If you are in America, in some cases, you can submit I-130 and I-485 together. That is good for you. It saves a lot of time. You get a lot of extra benefit out of that. However, you cannot just do it by yourself. It depends on the visa bulletin. If your category is current, then you can apply concurrent application of I-130 and I-485, and that is helpful. But to know whether your category is current, you have to see the visa bulletin. So that was our discussion for marriage-based application. If any of you are interested, we can help you about that.
Thank you so much, Mr. Mahajan, for that very detailed description of these kinds of processes. I think this has been helpful to us all watching. And now we are going to hear some questions. We have already have some questions lined up in the comment section. But before we head to other questions regarding other visa procedures, let us first hear some questions regarding the marriage-based process itself. So these are questions that have been sent to us via our email. So the first question about that is, how long does it take to get a green card through marriage? Mr. Mahajan, if you would please answer.
Well, it depends. It depends on many factors. Number one, whether your spouse who is a U.S. citizen or permanent resident. Those who are U.S. citizen takes shorter time to get green card for their spouse. Those who are permanent resident usually takes longer. And it depends on many other factors too. Also, whether the spouse, who is the beneficiary of this application, whether he or she is living in America or living in a foreign country, is also a big factor, because a lot of US embassies in foreign countries, they have huge backlog for many reasons. I'm not going that detail into reasons, but there's a lot of backlogs. It depends on embassy too. Usually those who are already living in America has shorter time than going through the embassy process. So it's very hard to say how long it may take. It can be 1 year to 3, 4, 5 years. So it depending on the situation.
Thank you so much for that wonderful answer. And another question that we have received is, can anyone get a green card by marrying another green card holder?
The short answer is yes. But yeah, it depends on many other factors too, but short answer is yes, they can.
Thank you so much for that answer. The third question that we have received is, can anyone work in the US if they marry a green card holder?
Well, just because you married a green card holder, you'll not get a work authorization. And working without work authorization is illegal. Please remember that. I know a lot of people do it under the table, in exchange of cash. It depends on the situation, but in terms of law, you cannot work without work authorization. And just because you married a US citizen or permanent resident, you will get a green card. That's not true. You have to apply. Once you apply, once your I-765 application is approved, only then you will be able to work in America legally. So that's the answer. Just because you're married doesn't mean that you'll get the work authorization. You have to apply for that. You have to get it approved. Then you'll be able to work.
Thank you, Mr. Mahajan, for that concise yet very clear answer. And the last question that we have in our reserve is, my wife lives in New York and I live in Alabama. Where should we submit the application for a green card, New York or Alabama?
You can submit in either place, either in New York or in Alabama, depending on what is convenient for you. I assume you are the one who is beneficiary. So if you apply in Alabama, it's good for you because you can find the fingerprint place nearby. But how USCIS may ask question, since your spouse lives in New York, why you are living in Alabama? I assume you're living in Alabama because of education. You can explain that thing that, hey, yes, we're married, but my wife, she lives in New York for this reason, and I live in Alabama for this reason. And if it's a good reason, like, education is a really good reason, so you can explain that, and that will help you. So it's up to you where you will apply, but you can apply anywhere.
Thank you so much. And any further questions, if you have, please email it to us regarding marriage-based green card or any other services that Rajullah provides, and we will do our best to answer you. We have also received some questions in the comment section of the live, so let's head to them. The first question is asked by Mr. 𝗦𝘂𝗍𝗆, and he says, what if my change of status application to F1 non-immigrant student is still pending, and my F1 program starts and my current non-immigrant visa B2 is expired? If USCIS does not approve my application, and later on, what will they consider my status? Mr. Mahajan, if you would please.
Yeah, this is a kind of very gray area. This is a legal gray area. There's a lot of gray area in legal world. So my understanding is that you are in B1, B2 visa status right now, visit visa, and you applied for change of status to F1 status. Until your F1 is approved, you cannot start studying in that university. Remember that part. Until your F1 application is change of status to F1 application is approved, you cannot start your education. However, as long as the application is pending, you can legally stay in America. Of course, you cannot work outside because under B1, B2, you cannot work, but you can stay legally in America because your application is pending. So right now, you have to wait until your F1 application is approved. Then you can start your education. Until then, you can just stay in America. That's like the short answer. And if you ask me what is the exact status at your situation at this moment, the exact name of the exact status is pending F1 application.
I hope that answers your query, Mr. Sharkar. Again, if you have any further queries, please do email it to us. Another question we have received from Mr. Rian Binte Kamal, and he asks, if a student gets C in 2 consecutive semesters, does it mean he is in the subject of academic disqualification?
It depends on the university. According to USCIS law, you have to maintain your student status with good academic standing. Now, what is good academic standing is determined by the school. USCIS will not determine whether you have to have like an A, B, or C, whatever. It is determined by the school. So you have to call your school, or you have to go to your school DSO office, designated school official office, and they will explain what is their system in their school. But in general, getting C is problematic. I think in most university will say you have to get at least B or something. But I would advise you to go to your DSO office and ask what is the situation there.
I hope that answers your queries, Mr. Kamal. Another question we have received from Ms. Mahmouda Akhtar, and she says, I had a query regarding NIW. If I get my I-140 approved, I'll need to apply for IVP from Bangladesh as I'm currently living here. My question, is there any risk to get refused in the visa interview? If refused, is there any chance to reapply or appeal? What kinds of documents other than cash can be submitted as financial documents? If you would please, Mr. Mahajan.
Yes, so you do not need to submit any financial document for your IVP application based on I-140. So yes, when you apply for NIW from Bangladesh or any other country in the world, you can apply for NIW, I-140. I-140 get approved, then you have to apply for IVP in your local US Embassy, meaning US Embassy, Dhaka, Bangladesh. Well, there's always chance of getting your visa application rejected. Nobody can guarantee 100% chance of approval. Nobody can do that because it depends on many factors. So let's assume that your application got rejected. And then, yes, you can appeal against the decision. You can reapply for that IVP. And there are a lot of supporting documents that you need to submit when you submit your DS-260 form to US Embassy Dhaka. In general, you do not need to show any financial statement because you applied for a green card application based on employment, like EB3 NIW. So in general, there is no financial statement required, but it's good to always have some money in your bank and show that you have like a solvent in finance. So it depends on like application. When you go to DS-260 level, there's a lot of supporting document you have to submit with your DS-260 application. Okay, I'm getting a call. Probably this is for this show. Let me see.
Of course, Mr. Mahajan. In the meantime, I hope that
Hello.
Mr. Mahajan is able to answer your query. Ms. Mahmoud.
Hi, I'm watching the live session.
Yes, you can tell your name and you can ask your question.
Okay. Okay, my name is Shimon. I'm asking regarding the condition of remove process. Like I got my green card actually 1 year, 9 months back, June 2021. So I'm on the nearby to the removal condition deadline. So it's like 90 days, including the 90 days right now. So how to remove these, or what the process should I follow, and what are the documents should I provide? Like, can you please discuss a little bit?
Yes.
And how to apply for that?
Are you still married with that person you got green card through?
Yeah.
Okay, then your removal of condition application is very straight, very easy. You can do it yourself. So if you go to our YouTube channel, I have a video on a step-by-step guideline how to apply for application for removal of condition. There is a form called I-751. You need to fill up that form. Your spouse needs to submit some affidavit that your marriage is going good, and also there's a lot of supporting document you need to submit to USCIS, and they will call interview for you and your spouse. Both of you will go answer all the questions they have, and then you will get like another green card that will valid for next 10 years. Since you guys are already married, right now you're married, it's a very easy process, a straight process.
Okay, so for removal of condition, they have interview?
Yes. Yes.
Okay. And what about the previous document that I submitted? So should I have to take all of these documents?
Yes. So in general, they will ask for up-to-date documents. So let's say your green card application based on marriage, you submitted, let's say, your joint bank account. So you have to submit the latest statement of your joint bank account. Let's say when you applied for a marriage-based application, you submitted a joint lease agreement for your apartment or like mortgage application. Now you have to submit the latest statement for your lease agreement and other things. So all the documents you submitted when you applied for a green card application, you have to submit the latest version of that document.
Okay. All right. Thank you very much.
No problem. Have a good day. Hi, Isabella.
Yes, and now we have more questions. Before that, Mr. 𝗦𝘂𝗍𝘆 has greeted us with a thumbs up. Thank you so much for watching the live. And a question from Ms. 𝗟𝗓, and she asks, hello, does getting C in 2 semesters consecutively mean academic disqualification and lead to deportation from the USA? If the student was sick, what are his or her options? Do you provide any consultation regarding this?
The short answer is yes, I do provide consultation. First, you have to contact your school DSO and see whether they deactivated your service or not. The first question is, if your service is still active, you do not need my help. You can just talk to your school DSO and see how to fix it. If they decided to deactivate your service, you can apply for reinstatement of your service account, and I can definitely help you with that. Our fee is $2,500 plus USCIS fee plus FedEx shipping fee. However, I would advise you to talk to your DSO first, try to resolve it there because it's free. It would be less expensive. But if you really need to apply for reinstatement because you are sick, your bad result in your exam was beyond your control, so I can definitely help with that. The name of the application is Application for Reinstatement of Your Student Status.
I hope that answers your queries, Ms. 𝗟𝗓. And so far, we don't have any more questions from our audience. Before we end the live session today, Mr. Mahajan, I wanted to ask if there is any update from the USCIS that we and the audience should look to.
Yes, there's a very big changes in the visa bulletin, and a lot of people, especially from Bangladesh, Pakistan, and like other countries like Nigeria and Burkina Faso, you do not follow visa bulletin because until recently, all that pretty much all the applications was current. So you just applied for I-140 and I-485 concurrently. It was everything was good, but until recently, the visa bulletin became a very important factor, and especially in this April visa bulletin, they even went backwards. So I encourage all of you to know how to learn the visa bulletin, how to study the visa bulletin, how to read the visa bulletin, because visa bulletin will dictate your future steps for immigration status. And in the recent visa bulletin in April, there's a lot of changes. So that's like one big immigration update. Another one is, because of the COVID, USCIS had a lot of flexibility in, let's say, applying for some application, RFE answer, some deadlines. There were many flexibilities. Recently, USCIS announced that they are going to cancel those COVID-related flexibilities. So, and not all the flexibilities has been canceled, but some of those has been canceled. So also, you have to check before moving forward with any kind of response or any kind of document submission, whether you will still have that flexibility or not. You have to make sure. So those are two big changes in US immigration in recent weeks.
Thank you so much, Mr. Mahajan, for that heads up. While you were talking, another question has popped up. Ms. 𝗟𝗍 𝗟𝗶𝘆 asks, I have GC. I applied for my husband 3 years ago. Now USCIS asked me for request for evidence for missing page 7 from I-130. But my question is why this is getting so late? What can I do to accelerate the case? Mr. Mahajan, your response.
The first of all, since you got a RFE, you have to answer the RFE. If you do not answer this RFE, they will reject your application. So I would highly encourage you to answer this RFE properly. And then, since it has been stuck for more than 3 years, there are multiple ways to expedite your case. There are some free tools to expedite your case, and there are some expensive ones. So let me tell the free steps first, and then I'll tell you the expensive one. Number one, contact your local congressman or senator's office. Remember, you have to contact federal congressman or federal senator. Your state congressman or state senator will not be able to help. So call your local senator or congressman's office and request for expedite processing. They can request expedite processing, and sometimes it works and it's free. So why not you take this opportunity? Number two, there is a office called Immigration Ombudsman Office. OMBUDSMAN, Immigration Ombudsman Office. You can also call them. They have a procedure to inquiry about your case, and sometimes this kind of inquiry helps. So this is also free, so you can take this opportunity. Number three, you can always call USCIS customer service phone number and inquire about your case by yourself and request for expedite process. Sometimes they will listen to you, sometimes they won't. But it's also free, so you can take this opportunity. Number four, and the expensive one, is called writ of mandamus. So since USCIS is taking longer than reasonable time, you can file a writ in federal district court and request the judiciary to inquire about your case. And this is a very effective one. In most cases, we get a result within like 60 to 90 days. Sometimes it gets a little longer. However, it's a very effective tool. At the same time, it's very expensive. We charge $3,000 plus court fee of $402. Plus, there's a FedEx shipping fee for almost 10 or 12 defendants, which is almost $200. So it is expensive. That's why try free steps first. If it works, that's great. If it doesn't, contact us. We'll file writ of mandamus for you. Again, the fee is $3,000 for us, $402 for the court, and around $200 for FedEx shipping. So I believe I answered all of your question properly. If you have any other question, you can ask me.
Thank you so much, Mr. Mahajan, for that response. I hope your queries have been answered, Ms. Jannat. Now we have another question from Mr. 𝗂𝘂 𝗟𝗶𝘆, and he asks, after submitting the I-140, is it possible to take work permit? Now I am an F2 visa and on process of submitting I-140. Mr. Mahajan, your response.
No, I-140 doesn't come with any work authorization. Just because you applied to I-140 or just because your I-140 was approved, that will not give you work authorization. However, there are some situations you can get. Let's say if you are in, if your spouse is in H-1B and if you are in H-4, then after I-140 approval, you can apply for work authorization. I-765, the name of the form is I-765. Also, After your I-140 approval, if you apply for I-485, then you also apply for I-765 work authorization, then you will get it and you can work. But just because you're going to apply for I-140 or just because your I-140 is approved, that will not automatically grant you any work authorization.
I hope that answers your queries, Mr. Arju. We have another follow-up query from Mr. 𝗦𝘂𝗃𝗍𝗏, and he asks, what if my change of status application to F1 non-immigrant student visa is still pending, and my F1 program starts, and my current non-immigrant visa B2 is expired? If the USCIS doesn't approve of my application later on, what will they consider my status?
Again, I think I answered this question. Your status would be called pending change of status to F1. And let's say if your F1 program, starts, you cannot join because it's not approved yet. You have to defer your admission. So let's say you applied for this summer and your F1 change of status to F1 is not approved before starting of the class. You can defer it to fall. If it's not approved before fall, then you can defer it to next spring. You have to keep deferring. You have to keep getting new I-20, and you have to keep sending the new I-20 to USCIS to add with your application. And as long as this application is pending, you do not have to worry about B1, B2 because B1, B2 is already gone. You are not in B1, B2 anymore. So your status is pending F1. However, worst case scenario, let's say your F1 status, like change of status application get denied, then you have 10 days to leave America or apply for some other kind of visa. This is kind of very tricky situation. I understand it's a very short time, so you have to, I'm requesting you to be mentally prepared. But if your application get denied, then you have to leave America within 10 days. That's the grace period.
I hope that answers your queries. We have another question, and someone named Dreamer asks, sir, can you please tell us about prosecutorial discretion? Mr. Mahajan, please.
Yes, the prosecutorial discretion usually applies to asylum application. I mean, it applies to any kind of court proceedings. Anytime there is a government party involved, anytime we file lawsuit against government or something, there is a lawyer called prosecutor. They represent U.S. government. So in general, in asylum application, there is a plaintiff who is our client, and there is a prosecutor who represents government. In many cases, plaintiffs' attorneys, they apply for prosecutorial discretion. In short, it's called PD, prosecutorial discretion. It means we request the prosecutor to make decision and request to the court. A lot of time, prosecutors, they approve the application. But in most cases, they don't, because their job is to defend the government. And their job is to say no to any kind of asylum application. That's their job. So in most cases, in prosecutorial discretion application, prosecutor will say, no, we do not approve this application. This is not a bona fide application. This is not a valid application, Your Honor. Please cancel this application. However, in some situations, some prosecutors, they're very friendly. They're very good. They say, yeah, this is a good case. Your Honor, please approve this case. So in short, prosecutorial discretion or prosecutor's discretion, either way you can say, in short, PD means you are requesting the government to make decision for your case. Sometimes it's good, in most cases it's not a good decision.
Thank you so much, Mr. Mahajan, for that clarification. We have another question from Mr. 𝗦𝘂𝗍𝗆, and he asks, I am doing diploma in China in computer science and technology. I want to go to America for bachelor's. Can I go directly from China? And is it better to go for bachelor's or for master's? Mr. Mahajan, your response, please.
Well, it depends, bachelor or master's. Excuse me. So, yes, you can come either for bachelor or master's, depending on your situation. In general, you may get some financial assistance in master's program. In most bachelor program, you have to pay by yourself. So money-wise, bachelor program is more expensive than master's program. Also, there are some other flexibility in master's program, so it depends. So it's kind of very hard question to answer because I do not know detail about you. I understand that you're doing your diploma in China. So probably with your diploma in China, you may not be able to apply for master's program in America, because to apply for master's program, they require a US equivalent bachelor degree. My understanding is that your diploma program is not equivalent to US bachelor. So you have to apply for another bachelor program here in America. Probably you will be able to transfer some credits from China to America. So in your 4-year program, probably you will get some credit for your diploma. That will help you a little bit. So I would advise you to contact a lot of universities here in America. A lot of universities, they have admission officer, and you can talk to them, and they will better assess your situation. We also represent 2 universities here in America. We have a student admission team. If you're interested, you can email us. Our student admission team will talk to you and see what is the best scenario for your scenario for you at this moment.
I hope that answers your query. Mr. 𝗂𝘂 asks again if there is any way to get work permit after accepting I-140.
Same answer. I think I already answered this question. If you did not listen to it, please watch our video again. You'll find the answer.
Yes. Again, the dreamer asks if any asylee granted for PD can apply for EB3.
Yes, that's another very common question I get all the time. When somebody apply for asylum, can they apply for EB3? So let me tell the answer again. This is good for a lot of people. So anytime your asylum application is pending, remember, anytime your asylum application is pending, you can apply for EB3. However, if your asylum application has been denied by any immigration court, if your asylum application has been denied by any immigration court, then you cannot apply for EB3. So if you want to apply for EB3, you have to apply before it goes to court decision.
We have another question from Mr. Raj Sigdal. I have a TPS and I'm also an F1 student. If I work in different field using my TPS, but apply for NIW for different field endeavor, will it affect my NIW application? I will only show the relevant work experience. Thank you so much in advance.
Yes, if you show the only relevant work experience, then the other work will not impact that much. Yes, you can definitely apply showing the only relevant experiences.
We have another question from Mr. Miraj Hussain. Now I am in the USA with F1 status. I have bachelor's and 10 years working experiences, electrical and RF communication and satellite communication. My wife has a medical degree, master level. Who is best suited to submit EB2 NIW visa application? We do not have any journal publication.
My wife have medical degree, master's level. Who can? Yes, I am. So first of all, both of you qualify for NIW, but my understanding is that both of your application is not very strong. Let me explain you why. Even though theoretically with a bachelor degree and 10-year work experience, you are eligible to apply for NIW. However, in most cases, it doesn't get approved. Usually people with a master's degree and 1 or 2 more experience in America get approved easily. But in your situation, it's not a very strong case. But however, you can definitely try applying. In our wife's case, since she has a medical degree, there is a problem with the medical degree. The problem is with a foreign medical degree, she cannot directly practice here in America. So in our NIW application, we cannot say that if her NIW application get approved, she will be able to practice medicine and being a doctor, helping people, because she needs to take USMLE exam and pass it. Even after passing the USMLE exam, she needs a residency program, which is very hard to get here in America. So without a USMLE degree, without a residency program, nobody with a foreign medical degree cannot claim that she will practice medicine here in America. So in this situation, we have some clients with a medical degree background. So we request them to have a public policy degree or some kind of PhD program where they are showing some research work. So let's say your wife has a master's degree in medical field. Now she's admitted into a PhD program, let's say in some university for like biotechnology or biology or virology or some kind of like medical related. However, in a PhD program, then we can highlight their experience as a scientist, highlight their experience as a researcher instead of medical degree, and we can apply for NIW. So in short answer to your question, I think your wife's case is stronger than you. However, she needs to get admission to at least a MPH program, Masters of Public Health, and complete MPH degree, actually, not just studying the program. She needs to complete her MPH degree and then apply, or she needs to get admission to a PhD program in any scientific field, have some research, and then apply for NIW. But right now, both of your application is not very strong.
I hope that answers your queries. Mr. Hossein Noor asks, hello, sir, can I apply for I-140 or I-1485 or I-1765 while my B extension I-539 is pending, and even after the initial B status has expired?
Well, the thing you said, I-140, I-485, and other firms, every firm has their own requirement. You have to meet the requirement. It's not just because you have like in B status, you will be able to apply for those. It's not. Every application has their own requirement. If you qualify, definitely you can apply. If you do not qualify, then you cannot. I have to see your background.
Yes, Mr. Hossein Noor, you are again advised to email us at our official email address. Ms. 𝗟𝗶𝘆 𝗟𝗶𝘃 again asks a follow-up question. In what type of reasons the expedite request is accepted?
Usually, if you can show some compelling argument, let's say, I think her application is like a marriage-based green card application, right?
Yes.
Yes, yeah, I think so. Yeah, in that case, you can say that you have like a newborn baby, and baby's father is not here. So if baby's father can get green card, it's good for the baby. Your financial reason, like with your just one income, you cannot survive because of the inflation. So financial reason, like a hardship of U.S. citizens, like I believe you are a U.S. citizen, and if you have baby is also U.S. citizen, so hardship for U.S. citizens. Those are the compelling arguments for the expedite process.
I hope that answers your queries. Mr. Sajid Hassan Shrabon asks again, how much money should be shown in the bank statement if you want to go to America for bachelor's or master's?
It depends on your program. So in general, you have to show a statement for 1 year's academic tuition expense and 1 year's living expense. So let's say you are going to a university called ABC University. 1 year's tuition is, let's say, $20,000, and 1 year's let's say living expense is $20,000. So total you have to show $40,000 in the bank statement. So you have to show equivalent money for 1 year's tuition and 1 year's living expense.
I hope that answers your queries. Ms. Jerin Tasnim asks again, thanks for the answer. If I retroactively drop the course in which I got the C grade, and if my total credit or unit gets lower than the required one, as my university can offer me a reduced course load, can it further affect my NIW or H-1B visa option STEM application?
So NIW and H-1B has very less connection with this kind of situations. In NIW application or like H-1B application, they may not see this kind of things. You need to maintain your status for the sake of staying in America legally. And I would advise you to contact your school about those. But no, H-1B application is totally different. In NIW application, it's a different kind of calculation. Your academic grades will not be very important factor in those applications.
I hope that answers your queries, Ms. Tasnim. Mr. Miraj Hussain again asks, I have also done my master's program courses, but I never finished my final defense. If I finish my final research work and finish master's, that could help me to strengthen my case. What is your best suggestion? Do I need to finish my Bangladesh master's, or do I need to finish my master's program in the USA?
I would highly encourage you to complete your master's program in the USA, because US masters will have more weight in NIW application than Bangladeshi masters. So try to finish your American masters, and if you have relevant work experience, then your case would be stronger.
I hope that answers your queries. Mr. Hossein Noor says, thank you, sir. I want to visit your office. Could you please send me your email address? So
one is you want to visit my office and looking for email address. Both of the addresses are in our website. Our Washington DC address, our Bethesda address is also mentioned there. Also, our email address is mentioned on our website. If you visit our website, you'll get everything.
I hope that answers your queries, and that also goes out to all of our audience members. If you have any detailed questions that need responses, please do not hesitate to email us at info@rajulaw.com, or please look to the website to find more options in consultations. And with that, we are going to end today's live. We have had a very productive session. Thank you so much for your time, Mr. Mahajan. And audience members, you are free to join us next Sunday as well at the same time. Thank you so much. Looking forward to seeing you the next time.
Raju Law is one of the top immigration law firms in the USA. 100 officers, including law clerks and case managers, work in different departments under the supervision of Attorney 𝗦𝘂𝘶𝗶𝘆 and other associate attorneys in the United States. The success rate of 𝗦𝘂 law is over 99% in fulfilling the dream of people from other parts of the world. Family-based, employment-based, asylum, and green card-related services are available under one umbrella in 𝗦𝘂 law. In addition, this law firm is one of the best in the United States for obtaining services related to NIW, writ of mandamus, and student visas. The headquarters of 𝗦𝘂 law is in Washington, D.C. metropolitan area. We have a branch office in Atlanta, Georgia, to reach the services easily of 𝗦𝘂 law to everyone living in Georgia. Besides, we have a country office in Bangladesh. The contact address and phone number are shown for any immigration-related services. You can also email info@𝗦𝘂law.com. 𝗦𝘂 law is your safe address for assistance and advice regarding immigration to America.